So, welcome to podcast 2.6, carrying on looking at certainty of intention, and now looking at the issue of whether separating property can indicate an intention to create a trust. And here the leading case is arguably Kayford. The facts of Kayford are pretty straightforward. You had a company that sold particular products to consumers, and consumers would send in the money first, and then they would get the goods delivered to them at a future date. As it happened, this particular company was in financial difficulty, and the managers, realizing it was in financial difficulty, went to their accountants and said, well, what do we do in particular with the money of customers who've paid but haven't yet received their goods? The accountant said, well, what you do is you should put that money into a separate bank account in order to protect that money if insolvency were to ever happen, or to actually happen. And that's what they did. The company ultimately did go insolvent. And as you may or may not know, when a company goes insolvent, it may go into administration or in liquidation if it's in real trouble. In both those scenarios, the insolvency practitioner who's appointed to kind of look after the administration or the liquidation has to make an audit of all the assets of the company, because they need to know what belongs to the company and what doesn't, and what they, can they pay their creditors and so on. The issue arose as to whether or not this money in a separate account belonged to the customers who hadn't received their goods, or whether it was money belonging to the company. Now, clearly, if you just looked at it from a legal common law perspective, the money was in an account in the company's name, therefore it belonged to the company. Therefore, the insolvency practitioner could use it to pay off the debts of the company. However, those who were representing the customers who hadn't got their goods argued otherwise. They said, no, equity should step in here, because the reality is that by separating the money out and by wanting to protect us, they've effectively created a trust. And the High Court, Mr. Justice Meggery, agreed. And he said there are two elements here to creating a trust. One is an intention to protect putative beneficiaries, like would-be beneficiaries, by putting money into a separate bank account. They don't have to use the word trust. Indeed, the accountants, even though they were, financially sophisticated people, didn't necessarily think that this was going to create a trust, even though they called the accounts trust bank accounts. They didn't say, oh, you should create a trust. So two elements are an intention to protect those customers, and a separation of the money into somewhere else. So one without the other isn't sufficient, because you could be putting the money into a separate bank account for just purely internal administrative purposes, so that you know where all the different sources of income are, for example, right? You have money from suppliers or from customers and from investors, and so there could be a million reasons why, or several reasons why, I exaggerate, money might be put into separate bank accounts. So having that intention to protect therefore creates a trust. Ditto the other way around. Having an intention to protect without moving the money separately shows you haven't kind of actioned that intention to protect. You've just kind of left all the money in one place. Obiter, Mr. Justice Meggery, said, well, there could be another way, not on the facts, but there could be that the contract between the two, the customer and the company supplying the products, could have said that the money remains on trust for the customer until the goods are delivered. Or if a customer was, strong or powerful enough, they could say, look, we're only going to buy this on condition that the money that we pay is held on trust and in a separate bank account. Now, either way, either the company doing this because it wants to protect, or by agreement, a trust would be established. So I think that's pretty important when we're dealing with a situation where someone has received money and the purpose for that money hasn't yet been fulfilled, and then you put that money into a separate bank account. And the effect of that is quite important, because it means if that company ever were to go insolvent, as it did here, that money does not belong to the company's assets, because actually it's held beneficially for someone else. Now, there is a contrary decision on almost identical facts in Re Fairpack. And Re Fairpack was particularly sad set of facts, because the people receiving, who'd paid money to receive goods, were goods that were going to be given to them as Christmas gifts, right? So they were buying Christmas gifts and contributing a bit of money over the year to save up for gifts that they would get in Christmas, but the company folded before they could get their hands on those Christmas gifts. So it's particularly unfortunate. The judgment there, again a High Court judgment, actually wasn't aware of Kayford. I think Kayford was cited in that judgment. It seemed like a policy decision, because if you read about it, you'll see that the judge there says that this is quite a radical thing for a trust to be formed, and therefore bypassing insolvency. So that kind of puts chicken before, that's putting the cart before the horse, really. The question is it a trust? Not what are the consequences of it being a trust? Because as we've already established, when we talk about certainty of intention in Paul and Constance and in the other cases, if it amounts to a trust, well, it is a trust, and the consequences are whatever the consequences are. Otherwise, we're kind of creating a trust to suit different circumstances and not creating a trust when it doesn't suit us for policy reasons, because we want to prioritize creditors, for example. It also doesn't sit particularly well when we're dealing with certainty of subject matter, which is the next subtopic, where, as you'll see there, where we're dealing with cash or tangible products, physical separation is necessary for there to be certainty of subject matter. So it seems odd that in Fairpack, separation and a desire to protect were not deemed necessary, when we know that for certainty of subject matter, physical separation is one important way that you can establish that what the assets are of a trust. Now, that all make a bit more sense when we talk about the next subtopic of certainty of subject matter. But I think most commentators, again, this isn't gospel, but most commentators would prefer Kayford to Fairpack. You're obviously free to make up your own minds. Next podcast, 2.7, looks at beginning to look at certainty of subject matter, and here we kind of distinguish between kind of three scenarios. Tangible property, so in other words, land, a car, a pen, a physical object, as opposed to intangible property, such as intellectual property. And then we also look at situations where people use very uncertain terms like, I leave you the bulk of my estate, or whatever is left of my estate, or I leave someone a reasonable income. Okay, so there are three podcasts there on subject matter, beginning with tangible property. Thanks very much for listening, and hope that's been useful.